The human resource management legal environment has become significantly more complex in the last 30 years. There has been a significant number of laws enacted just in the past 10 years that affect how organizations must do business. In addition, we have grown to believe that we value diversity in the workforce much more than in the 1960s and 1970s. In this course, we'll explore some of the laws that HR managers have to work with on a daily basis, and we'll also look in some more depth at diversity and why it's valuable in any organization. Discrimination is the act of making distinctions or choosing one thing over another. In HR, it's making distinctions among people. So you can quickly see that we discriminate every day. If managers don't discriminate, they're not doing their jobs. However, we want to avoid illegal discrimination based on a person's membership in a protected class. We'll discuss protected classes shortly. And we want to avoid unfair treatment of any of our employees at all times. Illegal discrimination is making distinctions that harm people and that are based on those people's membership in a protected class. Before we start talking about equal employment opportunity and all the forms of illegal discrimination in the workplace, let's take the opportunity to introduce you to the OUCH test, or OUCH test. The OUCH test is a rule of thumb used whenever you're contemplating any employment action to maintain fairness and equity for all of your employees or applicants. You should use this test whenever you're contemplating any action that involves your employees. OUCH is an acronym that stands for Objective, Uniform in Application, Consistent in Effect, and has job relatedness. Is the action objective or is it subjective? Something that's objective is based on fact, cognitive knowledge, or quantifiable evidence, not on personal feelings or prejudices. Is the action being uniformly applied? In other words, if you had any action in an employment situation, are you applying that same action in all the cases of the same type? Consistent in effect. Does the action take a significantly different effect on one or more protected groups than it has on the majority group? The 4/5 rule is a test used by various federal courts, the Department of Labor, and the EEOC to determine whether disparate impact exists in an employment test. If we're out of compliance with the 4/5 rule, we automatically have not necessarily broken the law. We do have to investigate why we're outside the 4/5 parameter, though. By the way, we can also look at the 6/5 to determine the possibility of reverse discrimination. It's the same concept with slightly different numbers. Finally, is the action directly related to the primary aspects of the job in question? The word primary will become very important later as we discuss the Americans with Disabilities Act, or ADA, and we call these factors essential functions. Remember that the OUCH test is a rule of thumb that does not work perfectly. It's not a legal test by itself.